Proceed. Then wait, let my SEO come. Who will take this lead? দেখুন দেখুন কি হলো? This is a hearing matter. How many matters are there? Then another. Hearing matter. A paper book ready?
Yes.
Give it.
May I permit to mention this? One CRR of 265/2025 extension of interim order, Your Lordship. It expired yesterday.
Wait, just criminal motion matters. Just hand over the slip first. Criminal motion. Yes, criminal motion. Just hand over them. Any civil motion? Extension of interim order.
Yesterday it was expired.
Yesterday expired. Why have not mentioned it earlier? Under the heading extension of interim order.
My lord, may I permit to mention, my lord, FMA TMP matter, my lord, for admission.
Admission.
My lord.
Give it. It admission hearing as well. Give it. Motor vehicles.
Motor vehicles, my lord.
It admission has been.
My lord, may I be permitted to mention one CRR matter or hearing matter, my lord, on the last of hand.
Give it.
One for hearing.
Segregate it. Two applications, segregate it. Applications for what, madam? Section 5. Both the section 5. Another hearing. Give it. Hearing. It only in here for hearing and judgment.
These supplies some mediation audit for the appointment of the mediator. The mediator was already appointed, but mediation was not facilitated till date. The order was passed on 22nd of May 2027.
Who is the appropriate authority for holding mediation? Register. May I see the order? Mediator has been appointed by the learned registrar.
Website order, the mediator was appointed. But till now the mediation was for the reconciliation process has not been initiated.
I shall take up the matter with the learned registrar. It is not এটা আপনি আমার চেম্বারে পাঠান আমি রেজিস্ট্রার সাহেবকে একবার ডেকে জিজ্ঞেস করে নেবো যেটা কেন হচ্ছে না if necessary thereafter I shall list এটা আমার চেম্বারে পাঠিয়ে দিন any other mentioning call the list You are for the petitioner wife. Such being the position, this court thus finds sufficient merit in the instant application under section 24 of the Code of Civil Procedure Full stop para, consequently, the case record of matrimonial suit number 3525 of 2024 stands hereby withdrawn from the file of the Learned District Alipur, District South 24 Pargana, and the same stands transferred to the Court of Learned District Alipurduar with immediate effect. Para, consequently, Learned District Alipur, District South 24 Pargana is hereby directed to take immediate steps for transfer of the case record of matrimonial suit number 3525 of 2024 to the Court of Learned District Alipurduar. Full stop para before parting with. It is further directed that the Learned District Judge Alipurduar, on receipt of the case record of matrimonial suit number 3525 of 2024, is at liberty to keep the said case record in his file for disposal, or he may transfer the said case record to any other additional district judge for disposal of the said matrimonial suit. With the aforementioned observation, CO 45 of 2025 is disposed of. Department is directed to forward copies of this judgment both to the Learned District Alipur, District South 24 Pargana and Learned District Alipurduar for their information and compliance. ये रख दीजिएगा बोलन बाबू
No shame for this stage.
Who is for the petitioner?
Lordship,
Please,
Siddhi Shettiya.
देखिए दाओ
Quashing of GR case.
Siddhi Shettiya,
Lordship,
Rima Sarkar.
Lordship,
Madam Sarkar is very good. I'm keeping it password for some time.
Lordship.
Password.
Again, our board, the extension of each.
এক্সটেনশনের জন্য বিকাশ রঞ্জন ভরে যে সিনিয়র অ্যাডভোকেট লাগবে না, দুই যথেষ্ট। স্যারকে টাকা দোকান নিয়ে এসছেন পারমিশন। স্যার কি করবে এক্সটেনশন এক্সটেনশন হয়ে যাবে।
What is the affidavit of service?
But I have found the state will of the private party to not be service due to the technical problem that postal service. There are updates going on last 1.5 weeks. I could not have.
What is the postal receipt?
I put a thousand.
Why?
1.5 weeks there are updates in the postal service. They are not able to. They are not able to have it.
Speed force service is suspended.
On the table, actually 5 hours post one.
Then sir, I shall vacate the order. Order has been passed on 19th June. And we are in the month of August.
August.
Mr. Ganguly,
Oh, yes, Lordship.
submit an affidavit. I shall call for a report from the postmaster that on and from 19th June, the postal service has been suspended. Submit an affidavit. They are indicating that on and from 19th June 2025 till today, the speed post service is suspended in Jalpaiguri. The order has been passed on 19th June.
I have filed the extension on 5th August.
Forget about, sir, what I please try to understand. Are you in possession of the copy of the order date 19th June? That I intend to know. Where is the affidavit of service? Read. Where is the affidavit of service? Then I'm vacating this stay order. No, sir. If you are reluctant to comply with the order of the court, I will not extend. No, sir, not at all. Yes. Take down. Grant 2 of 2025. This is an application for extension of the interim order as filed on behalf of the petitioner. Stop there. On perusal of the earlier order dated 19/6/2025, as passed by a coordinate bench of this court, it reveals that by the said order, the said coordinate bench directed the petitioner to cause service of notice along with a copy of the instant application for quashing upon the opposite party number 2 by speed post. Stop para. On being asked by this court, learned advocate appearing on behalf of the petitioner could not furnish any cogent explanation for not effecting service upon the opposite party number 2. Stop para. In view of such non-compliance of the order of this court declines to allow the prayer for extension of interim order as made under cover of this application. Stop. Consequently, grant 2 of 2025 is hereby rejected. Full stop para. The interim order of stay as passed by this court on 19/6/2025 in connection with CRR 504 of 2024 stands hereby vacated. Full stop para. Department is directed to forthwith communicate this order to the learned trial court. Full stop para. Let the matter be listed before the next available circuit bench. Let the matter be listed before the next available circuit bench under the heading contested application. Full stop para. Learned Mr. Ganguly, learned advocate appearing on behalf of the respondent state, is hereby requested to ensure the availability of the case diary on the adjourned date. I'm vacating the Let him suffer. It is you এখানে এলো কেন? Oh, I'm sorry.
But copy of the application for extension of interim order not been served.
Who's for the petitioner?
I am for the. Opposite party by.
But I have not received the copy of.
Why you have not served, Mr. Mishra?
I will repeat the service in the course of the day, my lord, kindly put the matter on the.
What is the matter about?
My lord, the matter is about, my lord, order 6 rule 17 application has been turned down by the learned tribe. You are against which that.
You are the
And the husband,
petitioner.
and the petitioner.
Stop para. On behalf of the petitioner husband, an accommodation has been prayed for. Full stop. Prayer for accommodation is considered and allowed. Let the matter be listed on. Let the matter be listed on. আজকে হচ্ছে কত তারিখ? 13 না? Let the matter be listed on August 18, 2025 under the heading contested application. The application for extension of interim order being IA number CAN 1 of 2025 will be taken up at the time of hearing of the instant revisional application. Stop para. Learned advocate on record for the petitioner is hereby requested to supply a copy of the IA number CAN 1 of 2025 to the learned advocate for the opposite party wife positively in course of this law.
I got the petition laid by.
Wait, please, your lordship, my lord. My lord, this is my application, my lord, for the extension of the interim order, my lord. The first order was passed on 25th of May 2025, my lord. Subsequently, it was extended on 4th July 2025.
My lord, I am for the opposite party number 2, my lord.
Give me a second, sir. Give me a second.
My lord.
My lord, page 11 of the application is the first order, my lord.
Who is for the opposite party number 2?
Yes, my lord, I am for the opposite party number 2, my lord. My lord, in this matter, my lord,
You
Mr.
are for the
Mohit
state.
Mukherjee is-
CD is available.
My lord, one humble prayer, my
You are
lord.
led by him. He possesses the CD.
My lord, one humble prayer, my lord. My lord, I am for the opposite party number 2, my lord. In this matter, my lord, I am led by Mr. Mohit Mukherjee. My lord, I am praying for a very short passover, my lord. Kindly, my lord. Very short passover, my lord. My lord, we are opposing the extension, my lord. My lord, very short passover.
Let the main matter be heard.
My lord, a short passover, my lord. I am led by Mr. Mohit Mukherjee. Very short passover, my lord.
Very good.
My lord, if he's, my lord, then in that event, my lord, if the main matter can be heard next week, I'm being led by Mr. Sandeepan Ganguly.
My lord,
Who's
my lord,
available to
kindly
take
keep the matter as a short passover. Thereafter, my lord, kindly take the matter, my lord. Kindly, my lord.
Very good. Pass over for something.
Much obliged.
Number 7, my lord, and the order all pass on.
7 pass over. Yes, item number 8.
Why I got to the one twenty I the order husband has the petitioner level.
একটু BNSS টা একবার দিন তো। এই good. Yes, sir. Yes.
1,000 mother, one, and husband was unable to produce his evidence.
Agreed with what? How much has been paid, sir?
Now 30,000.
Rupees 20,000 for the wife and 10,000 for the. How many children you have? What do you do, sir? According to the wife, what is your avocation? Which paragraph is relevant? In the application?
Page 18, my lord, paragraph number 21.
You have a business of coal and joint family business of foreign liquor.
And my executive asset is not submitted to the school, my lord, I paid for it, and this was in the, and for procedure, not I also have some asset of details.
But you participated in the proceedings, sir. Take down. Why it is then for quashing? But you see the caption? $528 corresponding to $482.
Not for quashing, my lord.
So 528 is the 482 is the quashing of the proceeding.
Inherent part, but if you earlier for it, have today.
Very good. Ashun, the legality, propriety and correctness
the service copy available, and it's how on your location. I can go forward. That's why I will not.
So why have not indicated that?
That was not available, we said we record, it's the reading problem, and we speak out.
Who is the other side? Mr. Mr. Ganguly. কি বলছে রয়েছে বলছে কি রে বাবা? So you ought to have indicated. হ্যাঁ? বলেনি কেন? এই উকিল বাবুকে বার করে দিতে পারুন কোনটা এফিডেভিট অফ সার্ভিস, উনি বার করে দিক, তারপর আমরা কনসিডার করবো। ওনাকে উকিল বাবুকে দিন ওটা। From the postal receipt, tell me on which day it was served. এটা উকিল বাবুকে দিন আরেকবার, এই ফাইলটা একবার দিন। When the order was passed, when the order was passed, now I shall impose cost. Please answer, be specific to my question. Please be specific to my question. To the compliance of the order dated 19th June, that I shall impose cost of rupees 1 lakh. I'll add. ওটাই বলেছি না, ওটাই 1 lakh rupees with cost of rupees 1 lakh add করে দিই। Then why are wasting time? Sir. Remove the cost. So don't waste time. Be humble and honest to the court, sir. We are not inhuman, and that I am telling you. Order has to be complied with. You have come for quashing or the revision?
Between the parties, and the next complaint start to one coaching center from the premises. Thereafter, he deposited money and all this.
Now, tenancy agreement was executed by and between? Sir, please be quiet, sir. Please be quiet. Boshu.
And the accused part.
Who is the landlord, sir? Landlord is the accused.
And that,
So, landlord is the accused means Dilip Kumar Agarwal.
Yes.
Tenancy agreement for?
And thereafter, I sent legal notice to them, legal notice for payment of Then, thereafter, all this complaint that his room was locked by key and something also telling this is the frivolous complaint. And the operation of complaint.
What is the written complaint?
Written complaint start from page 15, man. It is the formal affair, man.
Now, tenancy agreement was taken for what purpose? Well, the party intends to let out the office premises as aforesaid.
Yeah, man.
And they agreed to occupy the said premises fully as a monthly, on a monthly rental. Very good. Then what happens, sir? Where is the FIR? Page number 15. Give me a second. You are for the landlord. What is the allegation in the written complaint?
Page 18,
Hmm.
paragraph 10, accused Dilip Kumar Agarwal was trying to change the law and replace it with their law with intention to lock all our property like AC furniture etc. And Dilip Kumar Agarwal made the complaint investment money as it to the premises. They are taking possession of everything, but police authority failed to take action. This is the complaint. I try to, but this is, but now possession with the tenant. From since there is nothing that we try to take possession of that. There is a dispute regarding payment of payment. They also send legal notice from the written complaint. I also send legal notice. There is a short stated matter regarding dispute and payment of rent file. There are some dispute. Now 175 156 complaint was brought.
Main allegation is against you is cheating.
Not I want to stop try to take possession of the premises. Paragraph 10, I page 80, the main allegation, main part. And earlier part is the regarding all story about the and all the things.
So what is the allegation of trespass is there?
Allegation of trespass not there, sir. They are saying that I try to replace the law, as you will try to take possession of the.
Oh, sure. In the instant application for quashing, as filed
11, I am for the applicant, Lord, petitioner. Lord, I request Lord that 12 may be taken up first. Both are same petitioners, not overlapping issues.
When
So
twelve-
That is not the right way. You are under the opposite party.
I am the petitioner, let me take.
11 is different.
in 11 and 12, you are appearing both in both the cases. So what is the harm if 12 is taken?
Because both the cases are not as what divided as.
Very good.
So on the different.
Since it is his child, let him. 12. It is a revisional application or quashing?
Lord, I have prayed for quashing along with the impugned orders, but Lord, I'll place my case, Lord, Lord, because there is the background and genesis, Lord, starts from a dispute of tenants. Lord, civil suit first in the year 1997, filed by the predecessor of the opposite parties. Against, not against me. Not against me, against one, Urmila Mittal. I was not there.
Who is for the state, sir?
Lord, it's a CR case. See.
Not against me, but against one Urmila Mittal.
Against one?
Urmila Mittal. Lord, I was not a party to that. The suit was decreed in favor of Lord, the predecessor of the opposite parties.
In that civil suit, who is the plaintiff, sir?
The predecessor of the opposite parties.
My grandfather. Subsequently substituted by us.
Yes, Mr. Chaudhary.
Now, my lord, in the year 2013, Lord, an execution case was filed. Lord, in that
Mr. Chaudhary, what was the nature of the suit?
Eviction.
Suit for recovery of possession or
Eviction.
eviction.
recovery of possession?
Yes.
Recovery of possession of from a tenant.
Tenant.
So Urmila, according to the plaintiff, then Urmila Mittal is the recorded tenant.
Yes.
Very good, sir. Take your seat. I will hear you.
Now, Lord, in the year 2013, Lord, the decree was put to execution.
Execution filed.
Yes. But surprisingly, my lord, the execution was filed against me. I was not party to the original suit.
You are not the legal heirs of the
No.
Urmila Mittal.
No, my lord.
Degree was passed against whom?
Against Urmila Mittal.
Sir, don't jump.
No.
Please take your seat, sir. I allow you to take seat. So, degree was passed against Urmila Mittal.
Yes.
But execution case was filed against you.
Yes.
You means Ramkrishan Mittal.
Mittal. Yes.
So, how Urmila Mittal and Ramkrishan Mittal is related?
Lord, Urmila Mittal and Ramkishan Mittal are relatives. But my lord, the case was filed, the execution was filed against me.
Urmila Mittal is still alive,
Lord,
according to you?
No.
Yes.
No.
Yes. She's alive.
My lord, anyway, my lord, I was not a party. The main crux of the matter is I was not a party to the original suit. My lord, this is a settled proposition of law. My lord, if a person is not a party to a civil suit, my lord, the decree cannot be executed against him. Now, my lord, taking this plea, I filed, my lord, a miscase in the execution case.
Order 21, Rule 97.
Yes, yes.
Seeking adjudication under Order Rule
Lord.
101.
Lordship. Now, my lord, somehow, my lord, the order, it was not passed in my favor. My miscase was dismissed. My lord, I preferred an appeal before the appellate court, not the district court, district judge. My lord, in that matter, my lord, the order was passed.
Just give me a second. When Order 21, Rule 97 was filed?
Lord, it was disposed of on 14th of August 2019.
Order 21, Rule 97, disposed of on
14th August 2019.
14/8/2019.
Lordship. And Lord, later on, the said appeal was carried, said order was carried in appeal. Lord, the appellate court, Lord, had set aside the order passed by the learned trial court.
Appeal allowed.
Yes. But what happened?
Appeal allowed, and thereby the appellate court declared your independent right to interest.
No. The appellate court said that since I was not a party to the suit, the decree cannot be executed against me.
But you claimed your independent right title interest.
On a different suit, my lord. I am coming to that. My lord, while this miscase was filed, my lord, simultaneously I filed another suit before the learned trial court. My lord, in that suit, what happened? That is the crux, my lord, from where the criminal case starts. My lord, in that suit, the trial court says, since you have filed a miscase in the execution case, so let the execution case be decided, let your miscase be decided first, and saying that, my lord, my my suit was dismissed. It was rejected.
No, Mr. Chaudhary,
Not sure.
let us have some academic discussion.
My lord.
Execution case was filed against you. According to you, against
Yes,
you.
yes.
According to you, you are not a party to the suit. So no decree was passed against you.
Yes.
You claimed your independent right, title, and interest over the suit property, rather decretal property. So you seek an adjudication of your independent right, title, interest under order 21 rule 101.
Got you.
That was dismissed. Appellate court allowed your appeal, but appellate court did not adjudicate your independent right, title, interest
No.
in that appeal.
No.
Very good. Then what happened?
Lord, during the pendency of the miscase, I filed another suit.
That I've understood.
Yes, suit on the same cause of action. The trial court says, since this issue is being adjudicated by the concerned court in the miscase, so we are not interfering in the suit. The suit is rejected. My lord, I have
Under 103 or 4 of the Code of Civil Procedure, Rule 104.
yes, my lord, this is separate suit I am saying. That miscase is there during the pendency.
No,
of
separate suit is a bar under order 21 rule 103 or 4, I believe.
Yes. So, my lord, on the point of maintainability itself,
Very good. Then
Yes.
what happened, sir?
then, my lord, I preferred an appeal over that suit also, this suit. And then starts, my lord, the criminal part. But what happens? This opposite party, the predecessor of the opposite party, my lord, he files an application before the CJL, a private complaint 200 CRPC, saying that in the suit, I have, my lord, annexed certain rent receipts. And those rent receipts are fabricated, forged, and I may be, my lord, called process may issued against me, and I may be put to trial. Separate criminal proceedings started by him. Lord, now that person dies, 2022. Lord, substituted by his legal heirs.
Who dies?
Ajay Agarwal,
Complaining.
complainant.
Very
He
good.
dies, substituted by his legal heirs. And Lord, the crux, the dispute, the main problem starts when a section 91 application was filed before the learned trial in the private complaint case, saying that the original rent receipts are with me. Lord, in that criminal case, I am the accused. Lord, an application is filed in the trial court under 91, not explicitly mentioned 91, but an application is filed praying for a direction upon me that I may be asked to bring the original rent receipts before the court, which can be sent for forensic examination. But I contest the suit, I contest the application before the trial court, saying that I, being an accused person, cannot be asked to produce evidence against me. If a person has put the criminal law machinery into motion, the onus and burden of proof is on him to prove his case. He cannot ask me to produce evidence against myself, which can be used against me. Lord, the trial court says, no, this is not testimonial compulsion. Since he has filed an application, you file the rent receipts, that will be sent for forensic examination. Lord, I prefer a revisional application before the district judge against that order. Lord, the learned district judge says that the order passed by the learned magistrate is an interlocutory order, which is not revisable. Henceforth, the revisional application is not maintained. Challenging that, I come before your lordship. Challenging the entire genesis of the application.
CRPC radical.
The order passed.
CRPC.
Now, Lord, the very first contention.
Give me a second. Say CRPC. This one. Code of Criminal Procedure. Yes, yes. Yes, Mr. Chaudhary.
Now, my lord, the contention, my lord, my contention is that I, being an accused person in the criminal case, cannot be asked to produce any document which incriminates me. My lord, the onus is on the prosecution. Be it a government case, be it a private case, my lord, it is the prosecution who will have to prove his case. My lord, Section 91, my lord, explicitly a constitution bench of the Honorable Supreme Court in the year 1965 has categorically held that Section 91 is not applicable to an accused person. Any person used in the section, the term any person cannot connote and include an accused person in a criminal case. So, my lord, I, being an accused person, cannot be asked to produce the rent receipt. It is his contention that I have forged and fabricated the rent receipt and used it in the suit. So he will have to prove his case by adducing evidence. He, without having that means, my lord, from the steps taken by the complainant, it appears that he has no evidence in his hand that he's saying that the rent receipts are forged. He is before the criminal court trying to gather evidence.
In that suit, your contention that you are the real owner, real tenant.
Yes, tenant with respect to a different property, different part of the property.
Place the FIR. Let me see
My
the
lord,
FIR.
the complaint. My lord, the complaint is in page number. My lord, may I take your lordship to the application first, the application file. My lord, page number 22.
Yes.
My lord will see that no nomenclature, no section, nothing has been mentioned. A
Very good.
simple application filed on behalf of the complainant.
Yes.
My lord, he says in para 2 that the accused person had filed the OC suit number 3 of 2013 in the Court of Civil Justice Senior Division at Kalimpong to claim tenancy and submitted the fabricated forged rent receipts and claimed tenancy rights based on the fabricated rent receipts. Thereafter, my lord, the whatever he is saying, filed an application under order. My lord, the story which I have narrated. Now, my lord, kindly come to the prayer, para 7. Next page. He says that the opinion of the forensic expert is required to determine the following facts: whether the question document is prepared, written and signed by late Vansidhar Agarwal, whether the quality of paper
It is
used,
specific electron. Yes.
Lord, whether the quality and paper used in the preparation of the question document.
Specific relief act. Specific relief act.
Lord, I pause here for a moment and I will say one thing. Lord, this Ajay Agarwal, Lord, who subsequently died in 2022, who was the complainant. Lord, he was not the author of the rent receipt. His father, Vansidhar Agarwal, was the author of the rent receipt. So, my lord, on this prayer, shall we find the prayer in the next page? An order directing the accused person to produce original rent receipts that were submitted, page 24. Prayer A is an order directing the accused person to produce original rent receipts that were submitted before the Learned Court of Civil Justice Senior Division.
Page number? Page number?
Page number 24.
Oh, I'm sorry. Yes.
Not an order directing the accused person to produce original rent receipts that were submitted before the Learned Court of Civil Justice Senior Division at Kalimpong in OC suit number 3 of 2013 and Miss Case 1 of 27. To send the question documents to the Central Forensic Lab Laboratory, Kolkata, or any other experts. And next, an order seeking opinion of a handwriting expert after examining the documents under question and the sample writings and signatures admitted to be of late Vansidhar Agarwal and of so and so orders, any other orders. Now, my lord, the person who has filed the complaint, Ajay Agarwal, he was not the author of the rent. His father was the author of the rent, Vansidhar Agarwal. He subsequently died. Lord, he filed in 2019, he filed the CRTs, but he expired in 2022. Now, my lord, it is being pursued by his legal heirs. Now, my lord, my contention before this honorable court that this is purely against the ethos of the law. My lord, the law says that an accused cannot be asked to produce any document which incriminates him. And this.
Mr. Chaudhary, give me a second.
Lordship.
Mr. Chaudhary, the document which he seeks to produce, the document he seeks to produce, that you have placed in your miss case.
Yes, photocopies. Yes.
That those have been placed.
Yes.
Those have been exhibited.
Yes, ma'am. That I have to take instruction of whether exhibited or not, but it was placed. It was placed.
And on the basis of the alleged fake rent receipt, a favorable order was passed by the district court.
No. The court was not in the, did not enter into Milord whether it is fabricated, forged or original. The court said that this suit is not maintained. On the ground of
No, I am concerned about the appeal which was preferred against order 21 rule 90, order 21 rule 101. What order was passed there?
Milord, the first court
Why
said.
have not annexed that those pages?
Milord, not, I have not annexed because those are not German, Milord. I was not concerned about the 91 application. That was the order under check.
Very good.
So, Milord, my contention is specifically, Milord, that whether what is there in the suit. Milord, if a criminal case arises out of anything, Milord, it is the prosecution who will have to prove his case. A prosecution cannot ask the accused person under 91 or under any provision of the CRPC to produce any document which, Milord, incriminates. Milord, that is what the Supreme Court says. And that law is still being followed. It is a 5 judges bench constitutional judgment.
What is that judgment?
I am showing to your lordship. Milord, that is still being followed, Milord. I have other high court judgments following the same proposition. There in the application.
What is the citation, sir?
Milord, it's AIR 1965, Supreme Court 125.
Page number?
Page number
AIR 1965 Supreme Court page?
1251.
Para?
Milord, para is from 31 to 37 and 41 is the relevant decision of the court. Milord, the Supreme Court.
Give me a second.
Lordship.
94 of the old act.
Old Act.
Section 94 of the old act is identical with section 91.
91, yes.
Yes, Mr. Chaudhary.
Yes. Lord, it was a 5 judges bench judgment. Lord, one of the honorable judge, Lord, dissented. The majority view was 4:1. So from para 31, Lord, the reasoning starts. Lord, why and under what circumstances, Lord, the Honorable Supreme Court was persuaded to hold that 94 CRPC or 94 of the old Act, Lord, is not applicable to an accused person. Lord, many foreign decisions of the United States of America, Lord, were considered by the Supreme Court back then. Lord, and thereafter, Lord, the Honorable Court came to this conclusion. Lord, para 31, kindly, Lord, see, page 14.
Yes, sir.
But says it seems to us that in view of the background, the legislature, if it were minded to make section 94 applicable to an accused person, would have said so in specific words. It is true that the words of section 94 are wide enough to include an accused person, but it is well recognized that in some cases a limitation may be put on the construction of the wide terms of a statute. Read a phrase on statute law, page 177. Again, it is a rule as to the limitation of the meaning of general words used in a statute that they are to be, if possible, construed as not to alter the common law. There is one other consideration which is important. Article 20, subarticle 3 has been construed by this court in Kallu case to mean that an accused person cannot be compelled to disclose documents which are incriminatory and based on his knowledge. Section 94 Criminal Procedure Code permits the production of all documents, including the above mentioned class of documents. If Section 94 is construed to include an accused person, some unfortunate consequences follow. Suppose a police officer, and here it is necessary to emphasize that the police officer has the same power as a court, directs an accused to attend and produce or produce a document. According to the accused, he cannot be compelled to produce this document under Article 23 of the Constitution. What is he to do? If he refuses to produce it before the police officer, he would be faced with a prosecution under Section 175 Indian Penal Code. And in this prosecution, he could not contend that he was not legally bound to produce it because the order to produce is valid order if Section 94 applies to an accused person. This becomes clearer if the language of Section 175 is compared with the language employed in Section 485 CRPC. Under the latter section, a reasonable excuse for refusing to produce is a good defense. If he takes the document and objects to its production, there is no machinery provided for the police officer to hold a preliminary inquiry. The police officer could well say that on the terms of the section, he was not bound to listen to the accused or his counsel. Even if he were minded to listen, would he take evidence and hear arguments to determine whether the production of the document is prohibited by Article 23? At any rate, his decision would be final under the court, for no appeal or revision would lie against his order. Thus, it seems to us that if we construe Section 94 to include an accused person, this construction is likely to lead to grave hardship for the accused and make investigation unfair to him. We may mention that the question about the constitutionality of Section 94(1) CRPC was not argued before us, because at the end of the hearing on the construction of Section 94(1), we indicated to the council that we are inclined to put a narrow construction on the said section. And so the question about its constitutionality did not arise. In the course of arguments, however, it was suggested by Mr. Bindra that even if Section 94(1) received a broad construction, it would be open to the court to take the view that the document or thing required to be produced by the accused would not be admitted in evidence if it was found to incriminate him. And in that sense, Section 94(1) would not contravene Article 23. Even so, since we thought that 94(1) should receive a narrow construction, we did not require the advocates to pursue the constitutional point any further. Keeping the above considerations in mind, let us look at the terms of the section. It will be noticed that the language is general and prima facie apt to include an accused person. But there are indications that the legislature did not intend to include an accused person. The words attend and produce are rather inept to cover the case of an accused person. It would be an odd pressure for a court to issue a summon to an accused person present in court to attend and produce a document. It would be still more odd for a police officer to issue a written order to an accused person in his custody to attend and produce a document.
I understand, sir.
So, my lord, after considering the entire thing,
Page number, paragraph 41.
paragraph 41, the court says that it is not applicable to an accused person. Now, my lord, this judgment is still the law. Lord, it is being relied upon by many high courts in similar and identical situations, Lord, where 91 is invoked to direct the accused person to produce any document. Lord, relying on the proposition of Lord, this state of Gujarat versus Shyamlal Choksi.
What is the order, Mr. Bhagupta?
Lord,
Which is under challenge?
Your trial court order is page 26.
Yes.
Lord, page 27 is the relevant part. Second last paragraph, Lord, he gives his reasons. Lord, it starts from at the outset.
Yes.
At the outset, on perusal of the complaint, it appears that the present case has been filed under section 193, 196, 199, 200, 465, 467, 471 of the IPC, read with section 191, 192, 463, 464 of IPC, alleging that the rent receipts filed by the accused persons in OC 3 of 2013 were forged. On the perusal of the said OC 3 of 2013, the suit was dismissed on contest as being not maintainable against the plaintiff accused. that has been wrongly mentioned, accused. So essentially, as per the submission of the learned advocate for the complainant, the production of rent receipts are required for the purpose of comparison and verification of the signature handwriting in the said rent receipts. This court is of the opinion that the production of such rent receipts with a view to comparison of the writing or signature or the impression is not the statement of the accused person and cannot be said to be of the nature of his personal testimony. Here it has to be mentioned that finger impressions or handwriting, in spite of efforts at concealing its true nature, cannot change their intrinsic character. Hence, the production of such documents for the purpose of sending the same to the expert does not mean that the accused shall become a witness in his own case or would infringe the accused's right against self-incrimination. Further, this court is of the opinion that as per section 71 of the Evidence Act, the complainant can send the admitted documents and disputed documents for expert opinion regarding the genuineness of the signature on the rent receipts. Furthermore, the production of the rent receipt is only a mechanical process which may throw light on the matter in controversy. Therefore, considering the discussions made above, the court is of the opinion that production of the rent receipt marked as Exhibit 7 series, it was marked as Exhibit in OC suit number 3 of 2013 are essential for proper adjudication of the present case in hand, and hence it is ordered that 6 rent receipts were to be produced. Now, my lord, the learned trial court, my lord, got swayed away on the premise that the document which is being produced by the accused person is not a testimonial compulsion. Lord, I fail to understand, my lord.
Sorry.
Is not a testimonial compulsion. That he is not giving testimony against himself. But my lord, the broader sense, the broader principle is that the accused person cannot be asked to produce a document. Milord, fingerprint, sample, voice sample, these are separate things. Milord, Selvi versus State of Karnataka, 2010 judgment, Supreme Court is clear that it can be taken. Milord, fingerprint can be taken. For handwriting, it can be taken of the accused. But here, Milord, this fingerprint, the document which is being sought by the complainant is not something which has been signed by the complainant himself. Sorry, by the accused himself. Milord, it is the rent receipt which is in the custody of the accused person. And he is saying that those documents are forged, you produce it under 91, I will send it for forensic examination. But that is not how the criminal justice system works. But I file a complaint against Mr. X saying that he has forged certain documents, and then I go before the court and say, kindly ask him to produce the document. That means I have nothing, my lord, to substantiate my complaint.
Anything more, Mr. Chaudhary?
Well, that is the only thing, and I'm not.
And what order has been passed by the London district judge?
District just simply says this is the interlocutory order, cannot be revised. Revisional jurisdiction is not mentionable in such 35 copies there.
That's all.
Milord, one thing I will say with respect to the interlocutory order, Milord, the question that whether an interlocutory order can be revisable is well settled. It cannot. It cannot. But Supreme Court says, Milord, that if any order which is touching or adjudicating the rights of the person in parties in the list, then that will not be treated as an interlocutory order. Milord, in the present case, my fundamental right under Article 20, Sub-Article 3 of the Constitution of India, that is right against self-incrimination, Milord, is being infringed. That is my specific plea by order of the learned trial. And I am challenging that order in revision before the learned district judge. The district judge considers it as interlocutory order.
Yes, sir.
My lord has already seen that. No person accused of an offence shall be compelled to be a witness against himself. So I say Article 23, Lord, which is the intrinsic right under Part 3 of the Constitution of India, my lord, which no citizen of the country can be denied of, that right has been violated by the learned trial court by passing the impugned order. So that touches, my lord, the rights of the parties, and henceforth the order is revisable. It is not an interlocutory order. My lord, the Supreme Court in, I'll just place one paragraph of that.
What is the citation?
1977, 4 Supreme Court cases. Page 137.
Page,
137. Para 6.
yes.
It says, let us now proceed to interpret the provisions of section 397 against the historical background of these facts. Subsection 2 of section 397 of the 1973 code may be extracted thus. The powers of revision conferred by subsection 1 shall not be exercised in relation to an interlocutory order passed in any appeal, inquiry, trial, or other proceeding. The main question which falls for determination in this appeal is as to what is the connotation of the term interlocutory order as appearing in subsection 2 of section 397, which bars any revision of such an order by the High Court. The term interlocutory order is a term of well-known legal significance and does not present any serious difficulty. It has been used in various statutes, including the Code of Civil Procedure, Letters Patent of the High Courts, and other like statutes. In Webster's New World Dictionary, interlocutory has been defined as an order other than final decision. Decided cases have laid down that interlocutory orders to be appealable must be those which decide the rights and liabilities of the parties concerning a particular aspect. It seems to us that the term interlocutory order in section 397(2) of the 1973 code has been used in a restricted sense and not in any broad or artistic sense. It merely denotes orders of a purely interim or temporary nature which do not decide or touch the important rights or liabilities of the parties. Any order which substantially affects the rights of the accused or decides certain rights of the parties cannot be said to be an interlocutory order so as to bar a revision to the High Court against that order, because that would be against the very object which formed the basis for insertion of this particular provision in section 397 of the 1973 code. Thus, for instance, orders summoning witnesses, adjourning cases, passing orders for bail, calling for reports, and such other steps in aid of the pending proceeding may no doubt amount to interlocutory orders against which no revision would lie under section 397(2) of the 1973 code. But the orders which are matters of moment and which affect or adjudicate the rights of the accused or a particular aspect of the trial cannot be said to be the interlocutory order so as to be outside the purview of the revisional jurisdiction of the High Court. But the same view was reiterated in a very recent judgment. I will not read it. I will just place it before your lordship.
Not required, sir.
But
That you
2022
don't pardon me with
Lord-
same line of judgment. If it is something new has been
No, same
discussed,
proposition.
there's very.
No.
So this is all about 12.
All above.
What is about, what is your submission with regard to 11?
11. But 11, same case. Very interesting. This person files the CR case in 2019, this CR case in 12, and in 11,
Same person.
same person, same accused person, same complaint,
Yes.
same rent receipt, new case, under 340 CRPC. On same facts, two complaints have been made. One CR case in 2019, another CR case in 2020 under 340 CRPC saying that I have committed perjury by exhibiting false rent receipts. Same cause of action, same set of facts.
So which one is the earlier?
2019 is the earlier. Item number 12 is the earlier.
Item number 11 is the latter.
It 11 is the latter.
When, where is the complaint in the item number 11?
That will be in page number 20.
Page number 20.
20.
Is a written complaint.
It's an application under 340 CRPC filed before the Court of Civil Justice Senior Division. Filed before the Court of Civil Justice Senior Division at Kalimpong.
Page number 20.
20 and 21. 2 pages complaint and 22 is the order registering a new case.
In the miss case which has been dismissed.
Yes. Same. Genesis is the same.
Mr. Chaudhary, what is your predicament in annexing those documents? The civil courts document.
Those documents has to be called for, because since my lord, it is with respect to the criminality of the matter, my lord, and purely on question of law. So, my lord, I did not ask for those documents.
So fabricated end receipt.
Yes. In that.
Allegation is for exhibiting fabricated end receipts.
My lord, in the
And-
earlier complaint also same allegation.
What order has been passed by the London Trial Court?
Here also, my lord, London Trial Court has invoked 91 and asked me to produce rent receipt. Same kind of application filed in both the matters. Same application, same relief.
No, application under section 340 CRPC was filed before the jurisdictional civil jurisdiction.
Yes.
But then what
Then,
happened?
my lord, kindly come to 22, the order. The CJM passes an order. Page 22, received a complaint duly supported by an affidavit from Sri Ajay Kumar Agarwal under section 340 of
Which
the-
was sent by the civil judge
Yes.
unit to CJM. And on the same day order has been passed.
Lord, I believe so. Yes, Lord. 1st of February 2020.
It was on 13/5.
First of February 2020.
This 13th May. It is also on 13th May. Same day.
May not the first one, item 12, 2019 complaint, your lordship is.
That is order number 52 dated 13/5 in CR number 23 of 2019. In item number, এটা কত?
Yes.
My lord, may I take a short leave, my lord? I have been asked by lordship to come once before court number.
Yes, yes.
Short leave, my lord. I ask.
Lord, that order was passed.
In CRR 396,
Lordship.
order was passed on 13/5. Come to page number 26.
Oh, the order impugned, my lord.
In the previous, yes, order impugned.
Yes, 13/5, same day, both orders.
Same day
Yes,
both
yes.
orders, identical orders
Yes,
have been
yes.
passed. Very good.
So, my lord, in 13, in item number 11, my lord, my plea is additional plea I am taking. That on the self-same facts, my lord, 2 cases have been instituted. One CR case in 2019, another CR case in 2020 under 340 CR. See the allegations, the set of facts, the parties all are same. So, my lord, on the self-same of facts, if a person is prosecuted twice, that amounts to double jeopardy. So, my lord, I am covered by judgment of the Honorable Supreme Court on that aspect also. So, my lord, in item number 11, my lord, I am praying for quashing of the second case I am moving here. I am praying for the quashing of the entire proceedings on the set of on the contention, Lord, that this amounts to double jeopardy and I cannot be put to trial twice on self-same facts. But in item 11, Lord, I restrict my relief.
Double jeopardy is also a
Constitutional right.
constitutional.
Yes.
That is in
And,
article.
Lord, I would say, Lord, it is a fundamental right, which is more precise than the Constitution.
Absolutely. It is an article
Article 22, my lord. Article 22. Sorry, my lord, article.
Twenty subsection two.
Two. My lord, in the 2019 case, the first case I know, Lord, I restrict my prayers only to the respect of quashment of the interim orders. Lord, though I have prayed for quashing of the entire proceedings, but Lord, now I restrict myself only to the quashment of the interim orders. So far as 91 and the production of rent receipts are concerned. But this case, Lord, item number 11, Lord, I pray for quashing of the entire proceeding, saying, Lord, that this amounts to double jeopardy when I am being put to trial twice for the same set of offense, same set of facts.
That's all.
Lord, on that effect, if your lordship allows me, I will place one.
Tell me the citation.
Lord, it's 2000, volume 2, Supreme Court cases, page 636.
2002, volume 6.
No, my lord, 2000, volume 2.
2000. I'm
2000.
sorry. 2000.
Volume 2,
Give me a second.
SCC
2000,
636.
volume 2, SCC,
636.
para.
Para 14 and 15. Lord. But that was with this case, the Supreme Court was considering the issue, Lord, a prosecution under the NI Act and a subsequent and simultaneous prosecution under section 406 and 420. Lord, in para 14, Supreme Court says, we agree with the submission of the appellants that the whole attempt of the complainant is evidently to rope in all the members of the family, particularly those who are the parents of the managing director of the Ganga Automobiles Limited in the instant criminal case without regard to their role or participation in the alleged offence, with the sole purpose of getting the loan due to the finance company by browbeating and tyrannizing the appellants with criminal prosecution. A criminal complaint under section 138 of the Negotiable Instruments Act is already pending against the appellants and the other accused. They would suffer the consequences if offence under section 138 is proved against them. In any case, there is no occasion for the complainant to prosecute the appellants under section 406, 420 of the IPC, and in his doing so, it is clearly an abuse of the process of law, and prosecution against the appellants for those offences is liable to be quashed, which we do. Accordingly, my lord, the appeal was over. So
That's all.
that is all.
What is senior?
Lordship is up on legs before courtroom number 2.
So what do I do?
Lordship kindly passes over the matter for 10 to 15 minutes.
Lord, one thing I will say, Lord, I am not hard at the motion stage. And Lord, I have a right of hearing to be hard expert. But since Lordship has directed me to serve a copy, Lord, I have done so. Lord, if the hearing is somehow not concluded, Lord, then I'll be praying for Lord an interim order of stay.
If I am alive, it will be concluded. Be rest assured. That you know Mr. Gupta for some time.
Yes,
So when I take up the matter, I conclude the matter.
Lord.
So
Substantially hard it can be disposed of also.
it will be disposed of,
Yes.
Mr. Gupta. Be rest assured. Either in your favor or in his favor. Some passover matters are there, no? All the passover matters. Item number 3.
Great.
Please be present at the time of hearing.
Yes, sir.
Not today. Item number 3, not today.
Lordship, for item number 6, I am appearing online. My lord, I am led by Mr. Moik Mukherjee. He is on his legs in court room number 28. Kindly
Not,
keeps it as a
not today.
My lord, kindly keeps it as a Passover. He's coming. My lord, he's coming. Kindly keeps it as a Passover.
Not
My lord,
today.
5 minutes. My lord,
Matter.
my lord, 5 minutes. My lord, 5 minutes. Kindly keeps it as a Passover. My lord, it's a very urgent matter. My lord, kindly keeps it as a Passover.
My lord.
Is there another hearing extension of interim order? Not today.
Yes, my lord.
Not today. Call the next man. Not today.
Lordship, in item number 14, I am appearing on behalf of the appellant petitioner. I am being led by Mr. Kamalesh Shah. My lord, I would be grateful if my lord kindly fix it on 19th. That's because Mr. Shah will be coming physically to move this matter.
19th of this month.
19th of August. Indeed, your lordship. That is on Tuesday.
Very good.
Great.
As per request made on behalf of the petitioner.
Or my lord, kindly take it, my lord, in the next vacation bench, my lord. It will be much better.
Vacation bench.
In the next vacation bench, my lord, if it
Who is he?
happen.
My lord,
I'm also the junior of Kamalesh Shah, my lord.
I will hear one.
Okay. ma'am.
Next vacation bench or next available circuit bench?
Next available circuit bench, my lord.
Who is the advocate on record?
my lord, Mr. Orko Mukherjee is the
But I'm the advocate on record, my lord. I'm the advocate on record.
It is item number?
14, my lord.
In the next available circuit bench?
Or my lord, 19 or my lord, the next available circuit bench, my lord. Whichever is convenient.
Take one. Don't make any alternate submission.
Actually, my lord, my senior is very much ill right now. He's having the viral fever. So
Then why
that's
are you
what
taking the risk?
that's what I'm saying, sir, my lord.
File in.
If you can keep it in the 19 or a day or after, my lord, 19, maybe in the next circuit bench, my lord. That will be much better.
What's your good name?
Arka Mukherjee, my lord. It's Orko Mukherjee.
On behalf of the petitioner, a request is made for placing the instance.
I don't know, 15, I'm for the state, but I'm holding the case diary also.
The file কি আছে দিন?
It's a 498 and domestic violence case. Sorry, dowry prohibition.
Mr. Mayank Rai, High Court, Calcutta, Circuit Bench at Jalpaiguri. Phone number, email. This is Mr. Rai.
Usually appear for him.
You know Mr. Rai? You know Mr. Mayank Rai?
Yes, I know.
None appears on behalf of the petitioner. Though
Against the petitioner along with two others under section 325, 357, 363, 365 and so on, as well as section 34567 of the Immoral Property Prevention Act 1956. After filing of the charge sheet, subsequently the ITC sections were only the sections under section 34567 of the Immoral Traffic Act, Lordship. Lordship, kindly logs to the FIR, the alleged facts was that a raid was conducted at City Center, Jalpaiguri, where when my lord, the petitioner and another person was found in two separate rooms with two separate ladies in a compromised situation. This is the whole sum and substance of the FIR. And subsequently, they were arrested. The ladies were taken to the custody and lordship, and this is the FIR which is page 13 of my petition. The so motu complaint. Although my lord, from the FIR, your lordship will get that the section 15.2 of the Immoral Trafficking Act has not been complied with. However, lordship kindly comes to the page 15, 16. These are the medical report where two ladies, my lord, they refused for medical examination. Now, my lord, 161 statement, although I have not annexed in my petition, I have annexed the 164 statement of two ladies. My lord, page 17 and page 19. Page 17 and page 19. The relevant part is page 18. I went to the spa for relaxation and a face mask. Many women came and brought me to the police station. Nothing happened at the spa. This is the 164 statement of one of the ladies. And thereafter, page 19, lordship, if your lordship kindly comes to page 19 and the relevant page 20. Page 20, the lady says,
you are the owner of the premises.
lordship.
Then
At best, I can be the customer of the premises. So, my lord, section 3, 4, 5, 6, 7 of the Immoral Traffic Act does not attract against any lordship. There are the plethora of judgments of the Honorable Apex Court as well as the High Court, along with our principal bench lordship, that the customer cannot be charged under section 3, 4, 5, 6, 7 of the Immoral Traffic Act. Now, lordship kindly comes to the page 21. And 22. This is the order whereby the petitioner has obtained the order of bail. Lordship, kindly see the observation. That is why I want to draw your
give me a second, ma'am.
Yes, your lordship.
Ashut. This is an application under section 528 of BNS or BNSS? What do you have written?
Yes, it's lordship. But I'm correcting lordship, kind of that. Leave lordship.
528 of the BNSS. Stop on perusal of the petition under consideration and after hearing the learned advocate for the petition, it appears to this court there is a fit case for issuance of notice. Stop para. The petitioner is directed to cause service of notice upon the opposite party state along with a copy of the instant application for quashing together with a server copy of this order and to file affidavit of service on the adjourned date. Let the matter be listed in the next available circuit bench under the heading adjourned motion.
I'm seeking stay in this matter.
Stop. The respondent state is directed to produce the case diary on the adjourned date. Stop. At this stage, learned advocate appearing on behalf of the petitioner prays for stay of the all further proceeding of sessions case number 89 within bracket 06 of 2022 is pending before the learned additional session judge, first court at Siliguri, Darjeeling. Then why you have stated that sessions case? Oh, after commitment it was again returned back. Oh, I'm sorry, very good. এটা কি লিখলাম বলো তো? না ওটা কেটে দাও। সেশনস কেস নাম্বার না করে লেখো stay of all further proceeding of GR case number of GR case number 280 of 20 as pending before the learned additional as pending before the learned additional chief judicial magistrate district Siliguri, Darjeeling. Stop. Considering the prayer of the petition, this court permits the trial court to proceed with the trial, but he shall not pronounce judgment unless in the said case, unless permitted by this court.
Finally, grant me the leave to correct the fault.
Oh, acha. Leave is leave is granted to the learned advocate for the writ petitioner. I'm sorry, the petitioner. No, sorry. Leave is granted to the advocate on record for the petitioner to correct the heading of the instant petition in court today. You are ready? Very good. I'll take up your matter background. Item number 12. Which according to you will be, I'll take up 11 or 12.
My lord, 12 they have argued long, my lord. I will start because to 11 is not maintainable, my lord. It's not filed properly. They have prayed for something else that cannot be granted in that application, my lord. It's a defective filing.
Very good.
They have to correct
What
it.
is your submission with regard to 12?
My lord, my lord, kindly see, my lord, I have to give the gist facts because what my learned complainant petitioner has said is completely not correct, my lord. My lord, a suit was instituted by my grandfather, my lord,
May I know your good name, sir?
Ajay Singhal.
Mr. Sinha.
Singhal, Singhl.
Yes, sir.
My lord, in 1997, my lord, a suit was filed by one Bansidhar Agarwal. That suit was with respect to a property that was in the third story, fourth story, and a room in top of fourth story, my lord. That was let out to one Urmila Mittal and her family members. Urmila Mittal, her wife, her husband, Anand Mittal, and Anand Mittal's brother, Ramkishan Mittal. So they are one joint family living under one roof. So tenants along with family members comes under tenant, my lord, the definition of tenant. Even the family members of the tenant will be included. So, my lord, their submission that without any title, they have filed and without making him a party, he has been evicted. That is not the case, my lord. He was duly represented. He was contesting the matter on behalf of Urmila Mittal before the learned trial court. He was well aware about the entire proceedings. In 2003,
So the accused was a family member of the Urmila.
yes, Urmila is the sister-in-law of Ramkishan Mittal, the petitioner herein. Now, my lord, what has happened after 2002, Bansidhar Agarwal passed away, my lord.
The original inducting landlord.
Yes, my lord. He passed away and he was substituted by his legal heirs.
Very good.
One of them was Mr. Ajay Agarwal, who was the complainant in the case. Now, in 2011, my lord, there was a will, probate, and a gift. The entire property was transferred to Mr. Ajay Agarwal in 2011. My lord, in 2013, a decree was passed in the suit, wherein the premises, it was not against any person, anybody, occupation. Urmila was the tenant and her family members were to evict the property, that is third story, fourth story, and room in top of the fourth story. This was the case. Now, my lord, after the decree was passed,
No, decree was passed against whom?
Urmila Mittal and family. She was the tenant. She was residing with her family members. Even Ramkishan Mittal was her family, residing together. There was no separate tenancy of Ramkishan Mittal. He was residing under the tenancy of Urmila. So when the execution was passed, it was with respect to the property under their possession. Now, my lord, till 2013, he never came up with any suit. When the decree was passed, to frustrate that decree, he filed a suit first. That is OC Suit 3 of 2013. In that suit, my lord, he has submitted rent receipts to the learned court as evidence under oath. That rent receipts were taken to the court. It was exhibited and marked, my lord. Now, my lord knows very well, once a document has been exhibited before a court, it is no longer the document of a person. It is a record, part of the record of the particular case. Now, my lord, whenever an original document is returned to the person who has presented it, it is done under one condition, my lord, that he has to submit an undertaking before the court that he shall produce this document whenever it is called for. Now, my lord, they have relied on several judgments, and I would say, my lord, every judgment cannot be taken into isolation, my lord, because it has to come in with the facts of the case first. Now, my lord, in the present
exhibited
facts,
document was returned from that court.
yes, my lord,
On
under the
undertaking.
undertaking by the person who produced it, that he will produce it to the court, like, you know, whenever we
To
exhibit.
which court?
To the civil court senior division at Kalimpong. Now, whenever a document we exhibit, we file a certified copy to the court, and the court then returns the
I have
original.
some idea about the charge.
Yes, my
I
lord.
know, sir.
So now, my lord, that undertaking is a very important fact here.
Undertaking before which court, sir?
Before the learned civil judge senior division, who was
But
in
not before the judicial magistrate court.
with respect to the
Those
document.
exhibited documents
Yes.
were part of the, those exhibited documents were part of the evidence in that suit.
OC 3 of 2013
which is pending before the jurisdictional
No,
civil
my lord,
court.
it's not pending.
I'm sorry, which was disposed of by the jurisdictional
Dismissed,
civil
yes, my
court.
Yes, my lord.
Which was disposed of by the judicial civil court.
Yes, my lord.
Now he has taken back those exhibited documents
Documents.
with an undertaking to refile the same as and when called for.
When called for.
And the undertaking was given to which court?
My lord, the civil court.
The
Where the
jurisdictional civil
documents were
The
exhibited.
jurisdictional civil court.
Civil court.
Very good. Then what happened, sir?
Now, my lord, subsequently, when the documents were exhibited, my lord, the complainant, he was given the copy, wherein he found these documents are not genuine. It was forged. The signatures are distinct. Now, Your Honor, in the complaint case, they have not annexed the fabricated rent receipts also. They have not annexed the admitted rent receipts also. That is from the Bansidhar Agarwal.
Complaint case.
Complaint case. We have submitted it before the court. The certified copy of admitted signatures and even the specimen signature. It's not my case that even without his production of rent receipts, I can proceed with that trial.
Admitted signature means
Signatures that were of Bansidhar Agarwal.
that has been admitted by him.
My lord.
That has been admitted by him.
My lord, that we have submitted before the court.
So how do you say that is an admitted document?
My lord.
How do you say that is an admitted document?
Signature, my lord, I am complainant who is disputing the fact the forged document and the complainant is admitting a document. Your Honor.
Sir, I cannot follow, sir.
Your Honor, the complainant has filed this complaint for forgery. He has also placed the original rent receipts which were actually issued by Mr. Bansidhar Agarwal before the trial court. And the certified copy of the...
Sir, I have understood that to that extent.
Yes.
No, where from you will get the concept of admitted document? That I intend to know.
No, admitted by me, my lord. That this is my father's signature, this is not my father's signature.
So if you admit that becomes a
No, my lord. I am not saying that in that sense. I have submitted both the documents to the court. While with the complaint.
You have submitted some document which according to you bears the original signature of the executant.
Yes.
And you disputed the signature as available in the rent receipt
submitted by the...
which have been marked Exhibit 7 series
Yes.
or 7 collectively before the jurisdictional civil court.
Yes.
And now what do you want?
Now, my lord, what has happened? Kindly see, my lord, these documents were exhibited way after the death of the person. These documents were even brought in light, not during the lifetime of...
For the sake of argument, even if I accept your contention that the signatures available on those documents are forged, so it has got to be compared with some admitted document.
Yes, my lord.
So where from the
My lord, he has filed a suit in 1997. In that suit, the rent
try to listen my question, sir. Try to listen my question. Try to understand what I am saying. A disputed document is to be, a disputed signature is to be compared with some admitted document.
Yes, my lord.
Am I correct? Or a specimen document. Suppose it is an allegation that Mr. X has forged my signature. So he has to give away a specimen writing, which has to be compared with that. Or in the alternative, I am to produce some admitted document, which is admitted of him. So how do you say?
There is a suit in which he has exhibited his signatures, my lord.
So those are not admitted. Those are, according to you, forged.
No, my lord. I have filed the suit. My father had filed a suit for eviction, wherein I have placed documents. My signatures are there. The original rent receipt that Urmila was paying, that is there. That is an admitted document. Urmila was paying rent. Urmila Mittal was all the time paying rent once he started defaulting. After that default only, the eviction case has started.
Achha.
So, Your Honor, in the record of 1997 suit, there are signatures of my grandfather, that are admitted.
But that was in that suit, he was not a party.
My lord, he was a party, my lord. Urmila Mittal was the tenant. He is a family member of the tenant. He was...
In that suit, you included all the family.
My lord, yes.
Sir, in that suit, you included all the family members, children, party.
No. Only Urmila Mittal, because she was the one who was the tenant under me.
Huh.
Under Urmila Mittal, everybody stayed. Now, Your Honor, if I have a tenancy in my name, then I cannot have my wife and my children having a they will live with me.
Where from you will get that concept?
Which one?
That if X is a tenant,
His
if-
family
if
members.
Y is a,
West
if
Bengal
Y is a-
Tenancy Act,
if
my lord.
Y is a tenant under X, automatically Y's all family members becomes a party to the suit.
No, no,
Where from you will get this concept?
my lord, if an eviction order is passed against one person,
Huh.
my lord, with respect to a property, any person who is in occupation of that decretal property has to be removed.
Naturally.
This is the law.
Unless
He has been
that
removed.
person has a independent right.
Independent right. Now they don't have. Now he is claiming his independent right based on these fabricated rent receipts. Now, Your Honor, there are two important factors. Now he is claiming tenancy of with respect to a property where he is not in possession with by this producing of the rent receipts.
So that question will be adjudicated by the judicial magistrate.
No, my lord, that I am not saying, my lord. I am saying there are two. It's my for the facts, my lord. I am trying to explain to this court that in this case, what he has filed rent receipts are with he has to. He is claiming his independent right based on this document.
Understand, sir? Absolutely.
Yes.
Understand. So for the sake of argument,
Yes.
even if I disallow this division application, then what documents will be sent for comparison?
My lord, my case, why I am asking for the original rent receipts is because there is a important factor that has to be ascertained by the court,
No,
my
no.
lord, and it is
Try to understand my question. For the sake of argument, if I uphold the order, then what are the documents or what signatures will be sent for comparison? That I intend to
my
know.
lord, those documents that were exhibited by Mr. Bansidhar Agarwal in his suit, he has filed a suit, he has submitted documents there, he has put his signatures there, sample signatures, rent receipts, all are there, admitted.
But in that suit, he was not a party.
My lord, he was never a tenant. He was living under the tenancy of Urmila as a family member.
Very good, sir.
He had no independent.
I got your point.
Now, Your Honor,
I
his
got your
suit
point.
was dismissed as non-maintainable. His application under 21, Rule 99, 100, 101 was allowed ex parte when the person who was the respondent died. After that, that order was passed. That has been set aside by the Honorable High Court. And then that has been affirmed by the Honorable Supreme Court also. And that suit has abated. The particular case wherein Order 21, Rule 99, 100, 101
This case was abated.
is abated till today. So it's not there. He has no independent right over the property. Subsequently, Your Honor, he has also been removed, evicted by the court because he in another proceeding, again he has come up and filed in the execution proceeding, he again came and filed Order 21, Rule 99, 100, 101. That was considered and again rejected. He has no independent right. He is...
No, very good. Then come to the point.
Yes, Your Honor. No, Your Honor, I have filed this case seeking that this offense is not just committed against me, my lord. It's been committed against the judicial system also. He has taken courts of law for granted and is submitting false and fabricated documents and claiming tenancy in one hand. And when the court is seeking, like, okay, my lord, my question is, what is if he is seeking till today, if he is fighting in an appeal that I am an independent tenant, what is the difficulty for him to produce the rent receipts before the court? If he is saying it is self-incriminating, my lord, that would speak otherwise. He is saying that those documents are forged, that means. If he is saying it is incriminating materials, if it was an original signature, what difficulty he has to produce it before a court of law? My lord, he has placed reliance.
He has shown the difficulties.
My lord, the judgment is not exactly covered in this case, my lord. They have 94 and 91 is not in the same footing, my lord. 94 is with respect to search. That time when you go for search, is there. There are certain another parameters. Now, my lord, 91 reads completely different. When the court is of the opinion that the document has to be produced to throw a light to the controversy, the court can call for such document, and it's not his testimony. That testimony is barred. I cannot take any testimonial statements that would implicate him. That is what 20 subsection 3 of the Article 23 of the Constitution speaks. It does not bar any document to be produced. Only those documents wherein testimonial, that is very important. Even in the judgment relied upon by the learned friend here, the court has stressed upon a testimonial, my lord. Here he is not testifying against himself. He has already produced a document before a court of law. He's not being a witness against himself. I have, my lord, there was a very short time, I could not go through the entire judgment. I have to give a reply on that because I have judgments which distinguishes these two facts. When 23 will be attracted and when Article 23 will not be attracted. I cannot be incriminated by my own words or a statement that is written. Those is incriminating materials. Now here he has said that he is a tenant with respect to an X property. He has filed a suit. In a suit, he has said that these are the documents based on which I am claiming tenancy.
No, the civil court has come to a finding that those documents are forged, and on the basis of that he cannot, his right, independent right, title, interest cannot be adjudicated.
My lord, there are two situations here. The court has also not affirmed his tenancy right. The suit has been dismissed. Why? Because section 47 was there. He had to file 99, 100, 101. Now once 99, 100, 101 was filed, his order was set aside and subsequently that application is abated. So he has no independent right.
He could not prove his independent right.
He could not prove his independent right. Now, my lord, I am trying to prove that he has forged a signature of a dead person. It's not that he has forged a document when the person was alive.
Then what, according to you, why section 91 is not at all incriminating?
My lord, section 91 is not incriminating here because, my lord, let's go through this section 1.
Yes.
What does section 91 read? It is completely different from what section 94 reads. And the judgment
94 of the old act.
Old act, my lord.
94 of not this act.
My lord, I am talking about IPC, CRPC.
No, the judgment is the old act, is equivalent to 94.
Now, my lord, kindly see. Let's read 91 together, my lord. I have to go through the old acts 94 once, my lord. But 91, what I am saying. Whenever any court or officer in charge of a police station considers that the production of a document or other thing is necessary or desirable for the purpose of inquiry, trial or other proceedings under the code or before the court or officer, such court may issue a summons to the person in whose possession or power such document or thing is believed to be, requiring him to attend and produce it or to produce it at the time and place stated in the summons. Any person required under this section merely to produce a document or thing shall be deemed to have complied with requisition if he causes such document or thing to be produced instead of attending personally to produce the same. Now, my lord, it says, what is the purpose? To throw a light in the controversy. Now, my lord, what the court has held, because court has heard their argument and said, no, you are not giving a statement against yourself. You have already produced this document before a court of law. So what is the difficulty in producing it before me? How is it incriminating? It is not his statement. It is not his signature. Now he is an beneficiary to it. He is claiming an interest from it. He is claiming a title from it. But now when the court wants to see that document,
very good.
He
Any
has
other point?
failed.
Any
Now,
other
Your
point,
Honor,
sir?
other point is, Your Honor, I have to give I would seek for a subsequent hearing tomorrow, my lord, because I want to place few judgments which will distinguish why
Come tomorrow.
these two cases are separate, my lord.
Come tomorrow, no issue. I will give
Let
you
it be part heard, my lord.
Take down.
Item number 17.
এইগুলো রয়ে গেল, এইগুলো রয়ে গেল।
I'm for the petition.
Item number?
Now, at first I have to draw your lordship's kind attention about the page number 10. Ten and 11.
Yes.
My lord, on that date, on 29th July 2025, we got the privilege of statutory bail. And learned trial court was pleased to enlarge me on statutory bail with a order that the 10,000, 20,000 with two sureties of one of whom must be local. Along with another, immense, which caused me immense hardship, that the local surety who will stand before me, for me, have to be landed property of 20 lakhs. Subsequently, on my lord, on 4th August, we have applied for the modification as per the provision of 483(1)(b). And then the order was modified to that extent,
10 lakhs.
10 lakhs.
Still you are facing difficulty.
10 lakhs, having landed property of 10 lakhs. We are applied for relaxation and that has been reduced to 20 lakhs to 10 lakhs.
What do you want?
My lord, that amount of 10 lakhs may be, wait,
My lord, on the earlier occasion, there was a direction to file supplementary application. I have heard all the parties. The last occasion, my lord, the honorable coordinate bench expressed his opinion regarding submission of bail bond of rupees 2,000. So in that regard, my lord, I have annexed the Jamin Nama.
Give me a second. sir. Yes, sir.
Yes, my lord. If my lord takes up the supplementary affidavit, my lord. On the last occasion, my lord, the honorable coordinate bench has expressed his opinion whether I have submitted the bail bond of rupees 2,000 or not. So in that
Which orders are under challenge?
my lord, the order is at page.
112 and 81.
Yes, my lord.
Certified copy you have given?
Yes, my lord.
Give me a second. sir. এই একটু বাইরে বড় তো এটা চেঁচামেচি করছে কারা? Yes, sir.
My lord. The parent order is at page 13, my lord, and it's a P1.
Page 13,
Yes, my lord, of my application, main application.
the affidavit.
No, my lord, the main application. Revisional application, my lord.
My lord, they want to order dated by the trial court.
38th of
August
August 2022.
There is page number 14.
Yes, my lord, P1.
It's not paginated.
Paginated.
It's not paginated in our copy.
Be that as it may. Who is the advocate on record?
My lord.
Kumar Santonu.
Yes, my lord.
Who is he?
My lord.
You. Senior member of the bar. You all depend upon your advocate clerk. Be that as it may. Very good.
My lord, if my lord peruse this order,
On condition up to pay 20% of the check amount on the next date.
yes,
That you have deposited.
no, my lord.
Then,
That is the reason I am before this court, my lord.
huh,
On the earlier occasion, the coordinate bench, honorable coordinate bench has queried that whether the trial court while granting bail can put this condition, because as per section 148 of NI Act, only at the time of appeal, the appellate court can impose this condition. Or else, my lord, under section 143, the trial court can impose this condition after commitment, not before that, after pleading not guilty or guilty. If my lord takes for once the NI Act.
এটা দিন না নেগোশিয়েবল ইনস্ট্রুমেন্ট অ্যাক্ট এই তো আছে এখানে Section?
First, my lord, kindly take up section 143.
140.
Hmm. Yes, sir.
Yes, my lord. Now, my lord, under this, my lord, the condition is that when I plead guilty or not guilty, and upon an application by the complainant under section 143, court can direct me to pay 20% of the amount. Otherwise, my lord, in 140, section 148, before the appellate.
No, what 143 says?
My lord, kindly.
Kindly please, sir. Are you in a hurry?
No, my lord, no, my lord.
Nowadays that everybody is in hurry except me, sir.
Power of court to try cases summarily,
Huh.
not withstanding anything contained in the Code of Criminal Procedure 1973, such as all offences under the chapter shall be tried by a judicial magistrate of the first class. Or by a metropolitan magistrate, and the provisions of section 262 to 265, both inclusive of the state code, shall as may be applied to such trial.
Yeah.
Provided that in the case of any conviction in a summary trial under this section, it shall be lawful for the magistrate to pass a sentence of imprisonment for a term not exceeding 1 year and an amount of fine exceeding 5,000 rupees. Provided further that when at the commencement of in the course of a summary trial under this section, it appears to magistrate that the nature of the case is such that a sentence of imprisonment for a term exceeding 1 year have to be passed, or that it is for any other reason undesirable to try the case summarily, the magistrate shall, after hearing the parties, record an order to that extent, that effect, and thereafter call any witnesses who may have examine and proceed to hear or rehear the case in the manner provided by the said code.
Hmm.
Now, my lord, let's come to section 143A, capital A. Section 143, capital A. Power to direct interim compulsion. Notwithstanding anything contained in the Code of Criminal Procedure 1973, 26 of 1974, the court trying an offence under section 138 may order the drawer of the check to pay interim compensation to the complainant. First, A, in a summary trial or a summon case where he pleads not guilty to the accusation made in the complaint, and B, in any other case upon framing of charge. Second, my lord, the interim compensation under subsection 1 shall not exceed 20% of the amount of the check. Third, interim compensation shall be paid within 60 days from the date of order under subsection 1 or within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the drawer of the check. If the drawer of the check is acquitted, the court shall direct the complainant to repay the drawer the amount of interim compensation with interest at the bank rate as published by the reserve. These are not equal here, my lord. I am on section 143A. The court has the power, but
As and by way of interim compensation.
yes, my lord. A, if he pleads not guilty, so at the time of bail application, my lord, can a court direct payment of 20%?
So it can direct for payment of interim compensation, but that cannot be that cannot be a ground for granting bail.
Yes,
That is your contention.
Yes, that cannot be a ground for bail.
Then what happened?
So that.
So you have not paid that.
No, I have not paid my.
For non-payment of that, your cross-examination was closed.
No, ma'am. It is pending till now. The court is not letting my any application. I paid for some time to let me give just give me some time. I will pay the 20%. But court refused to do so, and that's why, my lord, I have challenged the order dated first is, my lord, 1st of December 2023. May, my lord?
shall deposit the 20% of the check amount positively on or before the date fixed, failing which the defense of the accused shall be struck off.
Yes.
Then what complaint is present by filing Ajira, accused person is represented under section 317. The accused person files a petition for time, hard was considered, cross-examination, accordingly stands closed, no scope for the accused, as enough opportunity was given. So you want to cross-examine.
Yes, my lord, I want to enter the proceedings. The court has closed the cross-examination.
Very
Due to
good.
such non-payment.
No, that is not indicated. That is not indicated.
That is indicated on the previous order, my lord, 1st of December 2020.
Then why supplemented affidavit?
My lord, the court was in the as per order dated 30th August 2022, the bail order, there was no indication that I have submitted the bail bond of rupees 2000. So court inquired that have you submitted the 2000 rupees bond? So there was no document in my petition to prove that I have submitted. That's why I have come before the court granted me liberty to file supplementary affidavit. In supplementary affidavit, my lord, the last page is the Jaminnama.
No, what you have stated in your affidavit?
That I have submitted the bail bond.
What is the averment to that effect?
The Jaminnama, my lord, the last page.
Where is the averment to that effect in your supplemented affidavit?
Para 5, my lord, page 3.
Place.
It is submitted that the complainant of opposite party number 2 initiated a proceeding under such and such, being such and such.
And subsequently furnished bail bond of rupees 2000 before the learned SCM Alipurdwar.
Yes, madam.
That is the averment.
Yes, madam.
And what is the bail bond?
My lord, the certified copy.
So,
Annexed.
page number?
Last page, my lord.
Last 2 pages. Very good. Yes, what have you got to say?
Your Lordship, at the time of granting of a bail, the complainant, the opposite party number 2, before Your Lordship, had made a prayer under application under 143A for interim amount, Your Lordship, and that was allowed. It is the order is not reflecting that the prayer was made through an application, but that was made as per my instruction, Your Lordship. And subsequently, 20% of check amount was given as the compensation, Your Lordship. And subsequent to that,
So
Your Lordship.
that order was passed on the basis of an application.
Yes, Your Lordship.
Where from you get that?
As per my instruction, but the certified copy I could not obtain, Your Lordship. As per my instruction, that the application was made on the same day, Your Lordship, and on basis of that, 20% was given. 143A application was made, Your Lordship. From the order dated 30th August 2022, it does not reflect, Your Lordship, but the application was made. And subsequent to that, Your Lordship, the present petitioner chose not to be present in the trial court on several occasions. That would reflect from page 14, I believe. It's not paginated in my petition, Your Lordship. P2, no steps taken by the OP. Again, on 26, 2023, no steps taken by the OP, and subsequently he had to surrender and take second bail, Your Lordship. That was the consideration, Your Lordship.
The second bail order, my lord, there is no condition of paying 20%.
Yes, sir.
Only the trial court intend that the accused should be present at the time of evidence, or as because there are didn't content of the petition is not written well at all, Lorships and up to Lorships.
Take down.
What my learned, my lord, kindly, my lord, I want to reply.
No reply is required. Listen to my order.
to mention Lordship, Lordship, my extremely urgent because my interim order will be expiring tomorrow, Lordship. I was missed because the morning, Lordship, I was 2 minutes late, Lordship, because the Lordship, interim order will be expiring tomorrow, Lordship. Due to the water log in my area, Lordship, I was 2 minutes.
Lordship. I'm for the petition.
I'm for the OP respondent.
What the petition? Yeah, yes. So on that day. Do live stream টা বন্ধ রাখো।
That's it.